Imagine waking up one morning to headlines blazing across every news outlet. The sweeping federal immigration raids, which have haunted Southern California for months, have just been halted, effective immediately, in some of the state's largest and most diverse counties: Los Angeles, Ventura, Santa Barbara, Riverside, San Bernardino, Orange, Kern. For thousands upon thousands of families, this landmark decision marks a dramatic turning point, one that could ripple through every corner of California and, perhaps, far beyond. But what does this legal battle, sparked by a single judge's ruling, really mean? What are the stakes for immigration policy, local economies, the rights of millions, and the delicate balance between state and federal power? And why did one court order send shockwaves through political circles, business communities, and immigrant neighborhoods alike? To truly understand the magnitude of this moment, we need to wind the clock back, across decades of legal wrangling, shifting policies, and a deep, sometimes painful, history between California and Washington, D.C. The Golden State has always danced at the crossroads of federal mandates and state-level protections when it comes to immigration. In the early 1990s, California voters passed Proposition 187, a controversial measure that sought to deny public services to undocumented immigrants. The backlash was immediate and fierce, leading to years of legal battles, and eventually, the law's dismantling. Fast forward a few decades, and California was once again at the forefront, this time with the California Values Act, boldly pushing back against what many saw as overreaches from federal authorities. State lawmakers declared California a sanctuary state, limiting cooperation with federal immigration agents and prioritizing the protection of immigrant communities. Legal cases like Plyler versus Doe and Arizona versus United States became the battlegrounds where the rules of engagement were set. Plyler versus Doe, decided in the early 1980s, famously secured the right for undocumented children to attend public schools. Meanwhile, Arizona versus United States, ruled upon in the early 2010s, made it clear that states could not create their own immigration enforcement regimes independent from or in conflict with federal law. These legal precedents set the stage for a tug-of-war that has only intensified with each new administration, each new policy shift, and each new surge of migration at the border. Over the years, the debate has grown more heated and more personal. California developed a global reputation as a champion of immigrant rights. Sanctuary policies became a rallying cry for activists and a lightning rod for critics. Federal officials, especially under hardline administrations, have expressed deep frustration, sometimes threatening to withhold funding or launch federal legal challenges. Meanwhile, California's cities and counties, from Los Angeles to San Francisco, have expanded rapid response legal networks, community resource centers, and support systems for immigrant families, often working in opposition to federal enforcement priorities. Now, let's fast forward to July of the year 2025. In a move that stunned both supporters and critics, United States District Judge Makame Frimpong ordered an immediate halt to all Trump-era immigration stops and arrests in 7 of California's largest counties. The judge's order was not made lightly. The evidence presented was damning. A disproportionate number of Latino individuals were being stopped, questioned, and detained, often without reasonable suspicion, in clear violation of both the Fourth and Fifth Amendments of the United States Constitution. Advocacy groups, including the American Civil Liberties Union and the Coalition for Humane Immigrant Rights, had filed suit just days before. Their allegations were explosive. Federal immigration agents were not only using broad and racially charged stereotypes, but were driven by an arbitrary arrest quota, rather than credible intelligence or legitimate leads. The legal filings told a harrowing story. Dozens of busloads of workers detained in a single day, businesses raided without warning, and even United States citizens held by agents who refused to verify their identification. The statistics are staggering. Since the beginning of the year, complaints of racial profiling during immigration and customs enforcement raids have jumped by a jaw-dropping 40%. Latino-owned businesses, especially in targeted areas like East Los Angeles and the Inland Empire, have suffered a steep decline. Sales and foot traffic down by roughly 20%, threatening the livelihoods of countless families. Meanwhile, the federal budget for immigrant detention beds has ballooned by 15% compared to the previous year, raising questions about enforcement priorities and human rights. Behind closed doors, a leaked memorandum exposed that the Department of Homeland Security had even considered reviving enforcement tactics reminiscent of Operation Wetback, a notorious campaign from the 1950s that led to mass deportations and widespread civil rights abuses. The mere suggestion of such a move sparked immediate alarm and outrage among historians, civil rights leaders, and community advocates. The backlash has been both swift and multifaceted. California's Attorney General immediately launched investigations into accusations that ICE agents were posing as local police officers, conducting stops and raids in violation of state laws. Universities across the state, including the University of California and California State University systems, are now actively exploring sanctuary campus policies, measures designed to limit or block cooperation with immigration authorities and protect students from sudden detention or deportation. At the grassroots level, the California Immigrant Resilience Fund, first established in the year 2017, has reported a 30% spike in applications for legal aid and emergency services. Community organizations are overwhelmed with requests for assistance. For many Californians, the raids evoke a dark chapter in the state's history, echoing what University of California Davis law professor Kevin Johnson calls a clear and persistent pattern of targeting Latino communities that cannot and should not be ignored. He points to a historical context filled with repeated cycles of discriminatory enforcement, from the Bracero program's abrupt cancellation in the 1960s to the mass sweeps of the 1980s and 90s that devastated families and entire neighborhoods. Yet, federal officials remain insistent that their actions are lawful and justified. Tricia McLaughlin, Assistant Secretary at the Department of Homeland Security, dismissed the allegations as categorically false, arguing that enforcement is highly targeted, precise, and rigorously reviewed. She points to internal audits which, according to federal claims, show compliance with established protocols. However, as legal experts like Erwin Chemerinsky, Dean of Berkeley Law, have noted, this ruling underscores the judiciary's vital role in safeguarding constitutional rights against executive overreach, especially in the emotionally charged arena of immigration enforcement. The legal battle is only just beginning. As both sides prepare for a protracted fight, the stakes could not be higher. The core question: will this court decision reset the delicate balance between state rights and federal powers? Or does it mark just the opening salvo in an even bigger, more consequential conflict over immigration, economics, and civil liberties? One that will echo from Sacramento to Washington, from the halls of Congress to the streets of Boyle Heights? Right now, communities all across California are holding their collective breath. Business owners, already battered by pandemic disruptions and economic uncertainty, are bracing for new waves of instability. Advocacy groups are ramping up legal defenses, training volunteers, and preparing for what could be months or even years of legal limbo. One crucial question looms over everything: what will happen next if the federal government decides to escalate, or if California doubles down on its resistance? Let's explore the possible scenarios. The judge's decision to halt Trump-era immigration raids in 7 major California counties has thrown the future of immigration enforcement into entirely uncharted territory. There are multiple ways this could play out, and each path carries its own risks, opportunities, and potential consequences for millions of individuals, from immigrant families to business owners, educators, and policymakers. On one hand, the federal government could launch an immediate appeal, escalating the legal fight all the way to the Supreme Court. If that happens, the outcome could set a powerful national precedent, either reinforcing current constitutional protections or, alternatively, expanding federal enforcement powers in ways that could reshape immigration law for a generation. As Erwin Chemerinsky warns, the judiciary's role as a check on executive action is never more essential than when vulnerable communities are at risk. On the other hand, the ruling could embolden other states to follow California's lead. Already, local governments from New York to Illinois are watching closely, considering new measures to shield their own residents from what they see as overzealous federal enforcement. If California prevails, it could inspire a wave of state-level policies designed to protect immigrants, limit cooperation with federal authorities, and invest heavily in legal aid and rapid response services. At the same time, heightened tension between California and Washington, D.C. seems almost inevitable. Federal officials could threaten to slash funding for state programs, impose new restrictions, or even launch retaliatory lawsuits. These political maneuvers could have far-reaching consequences, not just for immigrants, but for the entire state budget, education funding, healthcare systems, and more. Meanwhile, local governments across California are not waiting for the next move from Washington. Counties from San Diego to Alameda are pledging millions of dollars in new funding for legal aid, rapid response networks, and emergency services for those at risk of detention or deportation. The California Immigrant Resilience Fund, which has helped tens of thousands of families since its inception in the year 2017, is now processing a record number of applications for legal assistance, a 30% surge in just a few short months. But the story is about more than politics and the law. The real-world impact is both immediate and profound, and it's hitting the economy hard. Latino-owned businesses, especially in the counties most heavily targeted by federal raids, have reported a stunning 20% drop in sales since the enforcement began. These raids have a chilling effect on our workforce, our supply chains, and the very economic stability of our region, warns Maria Elena Durazo, president of the Los Angeles County Federation of Labor. Industries like agriculture, construction, and hospitality, all critical to the beating heart of California's economy, are now facing acute labor shortages, delayed projects, and mounting uncertainty. The agricultural sector, for example, is particularly vulnerable. Many farms in the Central Valley rely on seasonal migrant labor for harvesting crops. With workers fearful of leaving their homes or even traveling to job sites, entire harvests are at risk. Some farmers have reported that crops have gone unpicked, resulting in millions of dollars in lost revenue and food waste. Construction sites, already grappling with supply chain disruptions, are now struggling to find enough skilled laborers. Hotel and restaurant owners, especially in tourist hubs like Anaheim and Santa Monica, are seeing both their workforce and their customer base shrink. Socially, the atmosphere in immigrant neighborhoods has grown increasingly tense and anxious. Reports of racial profiling during ICE operations have soared by 40% since January, according to data from the American Civil Liberties Union. Families are afraid to leave their homes, worried that a simple trip to the grocery store or workplace could end in detention or separation. Civic participation is declining, with fewer people attending town halls, school meetings, or even voting in local elections. In some counties, law enforcement officials have reported a troubling drop in crime reporting, as residents fear that any interaction with authorities could put them or their loved ones at risk of deportation. This is not just a California problem. The ripple effects are spreading across the country. National advocacy groups are mobilizing in unprecedented numbers, organizing rallies, filing lawsuits, and pushing for comprehensive immigration reform not just at the state level, but nationwide. Several universities, including the University of California, Los Angeles, and Stanford University, are considering adopting sanctuary campus policies, with faculty and students uniting to limit cooperation with ICE and protect undocumented students and staff. But it's not all fear and anxiety. In many respects, this moment of crisis is galvanizing a powerful new wave of activism, organizing, and community solidarity. Volunteer legal clinics are springing up in churches, community centers, and schools. Rapid response hotlines, staffed by trained advocates, are working around the clock to document abuses, connect families with attorneys, and ensure that no one faces detention alone. Grassroots organizations are holding Know Your Rights workshops, teaching residents how to respond if approached by law enforcement or federal agents. The push for reform is also gaining momentum in the political arena. Lawmakers at the city, county, and state levels are introducing new legislation aimed at further limiting cooperation with federal immigration authorities, expanding access to legal counsel for immigrants, and increasing oversight of detention facilities. The B-18 Detention Center in Los Angeles, for example, was recently cited for violating basic standards, including failing to provide adequate hygiene products and medical care. Public outrage over these conditions is fueling demands for stricter oversight, transparency, and accountability. So, what does all of this mean for you as a viewer? Whether you're a California resident, an entrepreneur, a student, or someone watching from halfway around the world, this struggle highlights a profound truth. The battle over immigration policy is not just a local or national issue. It's a global test of legal checks and balances, civil rights, and the power of communities to defend their most vulnerable members. If you are a business owner, understanding these dynamics can help you prepare for disruption, support your workforce, and advocate for policies that protect your community and your bottom line. If you're a student or an activist, following these developments can inform your civic engagement, shape your advocacy, and even influence your voting decisions in upcoming elections. If you or someone you know may be directly impacted, now is the time to connect with local resources, legal aid organizations, and community networks. California's rapid response systems have expanded significantly in the past few years, offering everything from emergency legal representation to housing assistance and mental health support. Knowing your rights during encounters with law enforcement is more important than ever. Organizations like the American Civil Liberties Union, the National Immigration Law Center, and dozens of local nonprofits provide up-to-date guides and training sessions, often in multiple languages, to help residents navigate these uncertain times. Ultimately, the answer to our central question, how authorities will respond and what broader consequences will follow, remains in flux. The next moves by the federal government, the courts, and California's leaders will determine not only the future of immigration enforcement in the state, but potentially the national conversation around civil liberties, federalism, and the rights of all individuals, regardless of status. As Tom Salens, president of the Mexican-American Legal Defense and Educational Fund, puts it, the court's action reaffirms that racial profiling has no place in law enforcement and that all individuals, regardless of race, ethnicity, or background, are entitled to equal protection under the law. Here's a little-known fact that most people miss. A recently leaked internal memo revealed that high-ranking federal officials had quietly considered reviving enforcement tactics reminiscent of the infamous Operation Wetback from the 1950s. That campaign led to the deportation of hundreds of thousands, if not millions, of Mexican nationals and Mexican Americans, often without due process, legal counsel, or even the chance to contact family members. The mere suggestion of returning to such policies was enough to spark widespread alarm, swift public backlash, and renewed calls for vigilance. It serves as a stark reminder that, even in the 21st century, past mistakes can return if we do not remain alert and committed to justice. Looking forward, several scenarios are possible. The federal government may double down, appealing the judge's order and setting the stage for a Supreme Court showdown, one that could redefine the limits of federal power for decades. California, in turn, may accelerate its efforts to build a legal firewall, investing more heavily in community defense, legal aid, and social services for immigrants. The outcome could determine not only who gets to decide the fate of millions of residents, but also the future of American democracy itself. The economic implications will be closely watched by analysts around the globe. If current trends continue, California's agricultural output, construction timelines, and service sector revenues could all take a significant hit, impacting supply chains, prices, and even the broader national economy. Businesses may need to adapt by diversifying their workforce, investing in automation, or advocating for policy changes that protect both their employees and their bottom lines. Politically, this confrontation could influence upcoming elections at every level. Candidates are already seizing on the issue, framing it as a battle between law and order and human rights. The outcome may well depend on how voters perceive the balance between national security and civil liberties, a debate that has shaped American society since its founding. On a personal level, this story is a powerful reminder of the resilience and courage of immigrant communities. Despite fear, uncertainty, and ongoing threats, families continue to build lives, contribute to their neighborhoods, and fight for their rights. Their struggles and victories are woven into the fabric of California's and America's history. Thanks for watching. If you found this deep dive helpful, please like, subscribe, and share your thoughts in the comments below. What do you think California's next move should be? How should the nation balance security with civil liberties? And what lessons can other countries learn from this ongoing struggle? Stay tuned for more stories at the crossroads of economics,